much, everybody. Thank you for your patience while we got this up and running. Technology certainly does make our lives easier, and we really appreciate you guys being here online and in person. Just a quick couple housekeeping things for those of you in the audience here today. The emergency exit is right there. You just go out that door, out the door to your right, and you're out in the parking lot, and drive home, be safe. Restrooms are down the hallway at the very end there. For those of you attending online, the restrooms, I'll leave that to your best discretion. So, as we go through this, I'll give a quick introduction of our presenters here today, read you their bios. During this, if you have any questions here, feel free to raise your hand and ask a question. For those of you participating online, type in the question there, and Wes here is going to be moderating that. He'll ask the question of the presenters, and we'll try and answer those as they come in. With that being said, we'll go ahead and get started. Let me introduce our presenters. We have two presenters today, Michelle Ballantyne from the University of Utah and Ryan Brady from Utah State University. Michelle graduated from Brigham Young University in 1987. Nobody's perfect. But she did graduate from the University of Utah College of Law in 1991, where she served on the executive board of the Utah Law Review, and she clerked for Judge Michael Murphy on the United States Court of Appeals in the 10th Circuit and Justice Christine M. Durham on the Utah Supreme Court. She practiced law at Vancott, Bagley, Cornwall, and McCarthy in Salt Lake City and joined the University of Utah Office of General Counsel in 1998, where she presently serves as Associate General Counsel. She advises the university on a wide range of matters, including copyright and trademark law. Ryan Brady received his BS in microbiology with honors from Brigham Young University, again, and his JD from the College of William and Mary School of Law, Prior to joining the Office of General Counsel at Utah State University in 2011, Ryan practiced law at an intellectual property law boutique in Alexandria, Virginia, and the Washington, D.C. office of Baker Donaldson, where his practice focused on intellectual property, prosecution, litigation, and portfolio strategy development. Ryan is a registered patent attorney. As Associate General Counsel at USU, Ryan provides advice on a wide variety of matters, including intellectual property, business and finance, real estate, sports law, technology transfer, corporate governance, and employment law. With that being said, we'd like to welcome them and thank them very much for putting this presentation together for us. We certainly appreciate all of your attendance and patience with us as we got this process up and running. With that being said, unless there's any immediate questions, I'll turn the time over to Ryan and we'll get started.
All right, I think we're up and running. This is a new experience for me. I've never done a webinar before, so this is going to be fun. And we've got a few people here in the classroom with us today, and we're glad they're here. Want to just invite everybody up front to please chat in your questions because we really want to address this to you. We've prepared a presentation that I think is going to be useful as a very high-level overview of intellectual property. And we're going to talk about a bunch of different topics, and I think it'll go pretty well. When James introduced the exit, we had like 5 people just leave. So we're a little worried that everybody else might leave too, but we're going to try and see how this goes. So let's bring up the slides, and here we go. So let's see, grab this pointer. All right. So today we've got a few different objectives, and I'm going to take care of a couple of them, and then Michelle's going to hit the other ones. But I want to talk about IP, intellectual property, and I'm kind of calling this a 101 course. It's that we think about things in university terms at the university, and so here it is, and it's going to be quick. We're going to fly through things, and it'll have a little fire hose feel to it, but I think it'll work out okay. We want to talk about patents really briefly. Those aren't going to be applicable to many of our audience today, and I think we've got about, what do we have, James, about 70 people maybe out there listening?
Correct.
online, but I think a basic understanding of patents is going to be useful for just terminology, becoming conversant in the space. We'll talk about trademarks a fair amount more, and then I'm going to turn the time over to Michelle to go through copyrights and fair use, and I think a lot of things that are going to be super applicable for today's audience. So let's just start high level with intellectual property and talk about what it is and maybe a little bit about its origins. First, intellectual property really is something that resides only in our heads. And a long time ago, people decided that ideas were valuable enough to give some kind of legal protection to. And that's where IP finds its origination. We're talking about things like inventions, creative works, which primarily deal with copyrights, right? These are works of authorship or artistry or other creative things. And then trademarks really has to do with brands, and so we'll talk about that, but it really is, again, something that exists. Its value exists not in hand or on a piece of land, but in our minds, and so that's why it is intellectual property. You know, we'll, let's see what I got here. We'll get the flow going here. Okay, so I'm kind of a history nerd, and so I like to know a little bit about where things come from. And most of the IP law that exists in the United States today has its origins in British common law. And that's where it really began. But it has an even earlier history back in Greece, even maybe as, you know, I think it's something like 300 BCE or something like that. Certain communities had patent-type systems where ideas or inventions could be protected. And then during the Middle Ages, kind of during that time of Renaissance, systems began to develop, such as one in Venice, and then France got on board with it pretty early too, in the 1500s, and finally the English got on board really around that in the 1600s, and from there it started to take off as a piece of law that wasn't just about tradition, or the common law, but instead it was written down and codified into statutes. And it was an important part of the founding fathers of America. They thought, gosh, we need to be able to promote innovation. We want to have these protections, and so they actually wrote it into the Constitution and introduced at least the concepts of patents and copyrights straight up in the Constitution. A few years after the Constitution was signed and ratified, the Congress put into action a Patent Act and a Copyright Act right there in 1790, and that's really the beginning of things. Trademarks took a few years still to go, right around, I think, the 1870s or so. Congress tried to enable and enact a trademark statute. It wasn't effective, and the Supreme Court actually killed it. And so they did another one in the 1880s, and that was really the first effective trademark statute. But has a long history, and it's kind of an interesting history because it tells us how important IP actually can be. And so, what is the purpose of IP? I like the statement here in the Constitution where it talks about promoting the progress of science and the useful arts. And so people might wonder, well, how does a piece of intellectual property, how does this concept actually promote progress or innovation? And I don't know, any ideas here from our audience? I'm going to grab a microphone too. If I turn this on, will that just make it go?
It should work, yes.
Okay. Any ideas? Progress? Okay. Well,
I think, I can see progress going forward in a more powerful way with some structure. When you know that you're working, say you're a scientist or an by having something official or some kind of ownership surrounding what you're doing, I think that's very motivating, and it puts it on paper. It's something that's tangible, that you can share, and having protections around that is important in increasing that body of knowledge or that community.
Perfect. I think that's a perfect answer. It's a better answer than I would have given. That's exactly on point. I think what we've got is a system that puts value on these ideas and these creative works, and what happens as a result of that is it's something that can be sold, it's something that can be transferred, it's something that can be enforced. It would be a pretty rotten thing to put your life's work into that great American novel, only to have it then published by somebody else and sold, and somebody else profiting from that. And that's what intellectual property does. It generally just gives people a motivation to create, and then they have a period of protection. And those periods are dependent upon the kind of intellectual property. So patents are going to have, inventions are going to have a certain period of protection. Trademarks will have a different one. Copyrights, of course, different as well. We'll talk more about those. In the U.S. today, we have really these 5 primary categories of intellectual property. Today we'll talk mostly about patents, trademarks, and copyrights. There are a few other categories of intellectual property that do exist internationally, such as industrial designs and some things like that. But we don't have a super rigorous system here in the United States for that. So we're going to focus today on these. And I think in particular, trademarks and copyrights, that's where we'll put most of our focus. So when you have these intellectual property rights, you're able to do a few things. And sometimes this gets a little confusing. You might notice that in that historical overview, the first English statute was a statute on monopolies, right? That's actually what they called it. So it was a way of cornering the market on a particular invention, right? And that's what generally you get with any of these IP protections. You get to be able to be the person who does that, but you have to enforce those rights. That's an important aspect here. The government's not going to enforce them for you, meaning they're not going to sue on your behalf. If I want to protect my intellectual property rights, I have to sue. And so the primary protections really are, what do you get? You get a legal cause of action against an infringer, and then you have to go ahead and affirmatively enforce that, and you can do so through maybe threatening a lawsuit or actually filing a lawsuit. It gives you a good negotiation position, but that's what you possess. Hopefully that kind of makes sense.
I have a question on that. Is that why often you'll see or hear about in the news letters, like a cease and desist letter being sent out? Is that kind of the first step in protecting that intellectual property?
Yeah, definitely. So that's kind of in our threatened space here, right? We're saying, hey, this is my space, stay out of it. And one of the things that's kind of tricky about intellectual property is it's become today so expensive to enforce your intellectual property, or it can be very expensive, especially in the patent space, that a lot of people who might actually possess a patent might not be able to afford to enforce it. And it's a challenge today, and where I think a lot of people are coping with that and trying to figure out the best way to do it. So let's jump in here to patents, and this is going to be super brief, but I think we can learn a few new terms. Patents are generally relating to inventions, and I think everybody probably knows that. There is a set of subject matter that can be patented, and I think it's best summarized right here on this slide. Processes or methods, these are things such as a method of making something, a method of producing a composition, or refining a chemical, for example, could be a process. Machines, things like an internal combustion engine, or an iPhone, or something like that as a device, and I think apparatuses kind of falls in that same space. Maybe that includes something like a specialized piece of glassware for a chemical reaction. Compositions, these are things such as pharmaceuticals, or maybe it's a new adhesive, or it's a new resin or plastic. And then finally, plants can be patented under certain circumstances and often are to great value. The patent system has yielded all kinds of useful things, and then I just kind of liked these ones. I got to show them to you because I thought they're pretty phenomenal. Here's a stick patented, which is awesome. That's right. The drawing is exactly what you're seeing there. It is an animal toy, and I don't know how this got past the system, but sometimes these things happen. This one might be even better, and you know, I know a few people who maybe actually sadly could use this. Right, a method and device for recognition of a collision with a pedestrian. So hang on, don't worry. Now you'll know what you've hit because you weren't sure before. So there are some really ridiculous patents that have issued, but there are also a lot of great things that have issued, right? So most of the pharmaceuticals, most of the things that we carry around with us all day long in our pockets and look at and check our email on, and the things, surgical procedures, and I mean the list goes on and on and on. Out in Michelle's space at the U, they're doing some really cool work in the medical space in association with medical school, and it's a wonderful thing. And if it wasn't for the patent system, it would be impossible to put the investment of time, energy, and resources into these things, because the moment you let it go public, other people would use it. So here's the patent process in a nutshell, and we could talk about this for hours, although you wouldn't want to. I can tell. You should see people's faces here. They're like, no, please don't do that to us. But it really begins with an invention, right, where somebody says, I've got an idea, and that's almost all it has to be, okay? You need to generally know how you would do it, and get it sort of reduced to practice. That's the term that we use. But once you've got your invention identified, you create an application. The application includes things like a specification. This is a description of the invention. It's going to include drawings. It's going to tell, it's going to describe how, for example, that new bumper is going to detect that it's a pedestrian and not, a lamppost. And it's going to have all of those kinds of things in there. You file the application with the United States Patent and Trademark Office, or even with an international office or a foreign patent office. It goes through a review process, which the term for this is prosecution. Okay, you'll hear that, and you usually think about it in association with Perry Mason or somebody like that, but patent prosecution is the review process. This is where a patent examiner gets involved and say why he thinks it's patentable or why she thinks it's not patentable, and it can be a long process. It can take years to argue back and forth. And then finally, either the patent applicant gives up and abandons the application because they can't convince the examiner that it should be a patent, or a patent gets issued. And this is what an issued patent looks like. Here's one of USU's recently issued patents, and has to do with spider silk. It's pretty cool stuff, a really interesting composition that we figured out how to make synthetically. And back to that prosecution, these things are evaluated for novelty. Another term just to maybe be conversant in, novelty really means that it's new, and non-obvious is a ridiculous term because it's a definition, it's a word that is defined by what it is not, but what it really means is that it is something that a substantial enough step has been taken forward from what else is similar that it wouldn't have just been an obvious adjustment. So we're looking for things that are not inches forward, but a good solid step forward, and so that's what things are generally going to be evaluated on. Patents last for about 20 years, time depending upon a variety of factors that are ridiculously boring but important to the person who owns the patent, and it can be licensed, it can be sold just like a piece of property, just like a piece of personal property or real property, and they're generally owned by the employer. And I say that because oftentimes people have this question. They say, well, if I invent something, who's going to own it? Well, it sort of depends on if you were doing your job when you invented it, then likely your employer is going to own it. And that also goes for state employees, typically. Please.
Questions. On the last slide, you mentioned that the patents can be either issued or abandoned. If the patent is abandoned, is that all the work that's gone into that? Is that?
The mic's not coming through very well. I'm trying to say it again louder.
Okay.
That mic's not working.
If a patent has been abandoned, can anybody pick that up, or kind of where the original person left off? Anyone can kind of pick that up and just start working on it, thinking that maybe they can convince the examiner?
They can't pick it up and try and get their own patent on it. When a patent gets abandoned, it really enters the public domain, okay? And so anybody can use it, but it's already gone through the patent process. One of the parts of the United States patent system that's important is you have to be an inventor. You can't steal somebody else's invention and go file a patent on it. You do have to make a declaration that you are in fact an inventor of the invention, which is a good part of our system. This doesn't exist in many foreign jurisdictions. So it's a nice protection for inventors to make sure that their things don't get absconded with. So there is patents in a nutshell. We got any questions coming in on those?
No questions online. You can request them, but...
Yeah, please. If you've got questions, send them in, and let's talk now. We're going to jump forward and talk about trademarks, and I think we're on a pretty good schedule here. So trademarks. Let's just go right into it. What is a trademark? What is the purpose of a trademark? A trademark is really, this might be kind of a funny definition, but it's the best one I've kind of come across. And it's an identifier, okay, associated with a good or service. So again, a little history. Roman blacksmiths, swordsmiths, used to stamp swords with a little mark, and that was maybe the conception of a trademark. And they would do it, somewhere on it, so you could know that.
Something's happening with your mic.
Oh no.
It was getting in and out.
Are we back and good?
Go again.
Okay. Stepping back. Is this sounding okay?
Yeah, it sounds right.
All right. So stepping back, Roman swordsmiths, they would stamp the hilts of their swords, and that was a source identifier. So you would know that Claudius, or whoever it was he's the best sword maker in the land, and now you knew where it came from. So this is, in today's terms, we think about these as brands, okay, logos, and just product names generally. So you can think of a bazillion trademarks because they're all around us. It may be, in fact, really the most common kind of intellectual property, in a sense, because of the commercial nature of the world that we live in. Everything seems to be a trademark, right? And the primary purpose, it's about avoiding confusion, okay? Trademarks exist because of what the marketplace recognizes. And so as you're thinking about your various state agencies and the trademarks that might be useful, and we'll go into some of those categories that could be useful, it's really about what the public perceives. That's the critical part of a trademark. I might think that I have a trademark, but if nobody recognizes it, then it's of no value, and it might not even really exist, okay? So a trademark that's locked up in a box, up in your, that nobody ever views, you can call it a trademark all the day long, but until you start using it, and the marketplace starts identifying it, it doesn't exist. And it's all about confusion, because we don't want one person to be able to offer, you know, his famous shaker chairs and get it confused with somebody else's quality of wooden chair, right? We want people to know what they're getting so that they're not confused. And this really goes to the goodwill of a provider, of a maker of anything, right? They want their quality, their goodwill to be associated with their product or service. And they don't want somebody else to be able to steal that goodwill. And it sometimes happens. People do it, well, it actually happens quite frequently, where people try and play off of the goodwill of another company or another person in order to sell their good or service. And we'll talk about that a little bit. So trademarks really are created by using them in the marketplace, and they also can be registered, but they don't have to be registered. And this is something that I think a lot of people get confused about. Trademarks don't exist because they're registered. They exist because they're used. And when you register a trademark, you'll eventually have to show evidence of its use, or else the trademark will be pronounced dead. And that's the word that's used by the United States Patent Trademark System is live or dead. So let's see. Trademarks can last for a very long time. They can last for as long as you want them to, as long as they're being recognized and being used. So there are trademarks that have been in existence for hundreds of years, and none of the other kinds of IP can last in this same way, with the exception of maybe trade secrets, which we're not going to talk about today. But trademarks, publicly known, they're out there and they can last for forever. So they can be exceptionally valuable. Here are some of the kinds of things that can be trademarked or people have tried to trademark. The list starts to get a little ridiculous, especially when you start thinking about the way maybe a celebrity or entertainment industry might try and approach things. I mean, names, logos, those all work. You know, UPS has a patent on that brown color. You know, that brown uniform color? That's right. They've got it. Not a patent, I'm sorry. They have a trademark on it. And it's associated with the service of delivering packages, right? Fonts could happen. Odors can happen so long as they're not functional. So you can't trademark a perfume, or, well, people have certainly tried, but it can be hard. Yes?
We have a question online. If you work for an organization with a trademark, do you have to ask permission to use it, such as a school district logo or a state logo?
Well, it probably depends upon the leadership of that organization. I think that's a great question, by the way. I think it's going to depend on the leadership. I think it's good to coordinate. Sometimes, for example, at USU, we find that some people run around with USU's trademarks or logos, and they might not do so in as responsible way as we would prefer, and we would like to have coordination occur beforehand. I think that's going to be the general thing. Michelle, do you have any thoughts on that?
I think what I might add is, can you hear me or do I need to?
As long as you speak loud enough, you should
Okay.
hear.
I think also what you need to keep in mind is, would your use be the institution's use? And exactly what Ryan said, with their permission. I know at University of Utah we have a trademark licensing office, and so they really will regulate who can use the university's marks, in what manner, and so I think you wouldn't want to assume necessarily that you can use it, and definitely not as an individual just because you work there. It would have to be on behalf of the institution.
Yes, exactly, because we're talking about a source identifier, right? So if the source is you, then maybe you should think about your own trademark. If you're speaking on behalf of the institution and have the institution's permission, or the permission of somebody who can speak on behalf of the institution, and I think you're safe. But as always, I think when I see any kind of conflict arise, it's always related to poor communication. And that happens within an institution just as much as without. So, please, another question.
Speak loudly when you do it, but then I have a question online.
Yeah, sure, yeah, it seems like a lot of the confusion, I think, can be avoided too by looking at the interplay of like the marketing style guide. You know, when do you use a logo? When do you use, official communication, whether it's internal or external? And then also, that with the policy on when you're doing it. And then if you've got, other factors in there, then it's always good. But yeah, having that paper trail is huge on making sure you're protected and you've got sign off from, bosses if needed when you make that communication. It's also helpful.
Yeah, most large institutions are the USU, we both have trademark licensing offices that are, their purpose is to keep a continuity of the brand and make sure they know how the brand is being used. If you're a smaller institution, you might not have that yet, and maybe it's time to think about, how are we going to implement that? What are the controls and processes that we might like to implement? Is there, I don't necessarily love policies, but do we need to write a policy on this and teach our employees how to do this properly? Trademarks can get out of hand quickly, especially in the digital space that we live in today. What's our other question?
All right, what if a school team is using someone else's trademark, like a professional team? Can they change it slightly?
Well, that's a great question, and it's one of those terrible attorney, it depends. Generally, I think it's best to avoid that kind of a thing, just because there's no reason to expose your institution to any kind of risk. Particularly if we're talking about a school team, like a high school team or something like that, I would very much avoid creating some kind of logo or brand that is similar to a professional sports team. These are resources from the sports teams that value these assets very highly, and they can be exceptionally aggressive in protecting them. And there's just no reason to expose yourself. At least that's my opinion. Michelle?
Right, and what I would say to that is, even if you change it slightly, as Ryan said, with trademark law, the test is likelihood of confusion. So it doesn't have to be an exact, it doesn't have to be the exact brand. It can be something close, and it could still be confusing because a consumer might say, well, that kind of looks like that, Seattle Seahawks logo. Are they somehow affiliated with them? And so that can be an issue in trademark and in copyright. We'll talk about that too.
Mm-hmm. That's perfect, yes. So, let's see. Lots of different kinds of trademarks. People have attempted, Mickey Mouse has been trademarked, right? Tarzan was trademarked by the author Edgar Rice Burroughs, and his family corporation today still asserts ownership over that trademark, even though I think the documents have long been, like the Tarzan stories have long entered the public domain from a copyright perspective. So trademarks can be used in really interesting ways, and people have tried all kinds of things. Let's see.
Ryan, do you have an example of an odor that's been trademarked?
I don't have a good example, but people have tried to, and one of the things about that is if it's a functional thing, then it can't be trademarked. So like a perfume, it wouldn't work. But if somehow you could associate an odor without the function, and I don't know how you would do that, but you can imagine it. I mean, maybe, for example, you're a paper manufacturer, and you want your paper to smell like, roses, and it becomes so distinct that the marketplace, when you open up that letter, you go, oh, this must be James Brown paper, right?
Yes.
That's the kind of thing that maybe is conceivable. Whether or not it happens very often it's unlikely. Yes, please.
What if students use trademarks in non-school sponsored activities?
Well, it's a good question, again, and education of students and helping them along is probably an important role and function. If it's not a school activity, though, it's just like anybody else using a trademark. I think the schools it's probably good practice to help students along, like if it's a student club or something like that. But if it's not a sanctioned activity, it's outside of our scope generally. At least that would be my opinion. All right. Here's a list of the kinds of things I think that generally public institutions are going to be interested in. Your name, maybe program names. Maybe you've got a program that's really, a new reading program that's really big, and maybe you have hopes that other schools might adopt it. That could be something that might be worth thinking about a trademark on. Product names, and then all of the logos. For example, down here in the bottom of our screen, see Utah State University with this little picture of Old Main, our historic building. This is a logo. Utah State University owns the trademark for the text Utah State University. And we also have this trademark, which is a logo, and you'll see those, and I think people are generally familiar with those. Yes?
How concerned should we be if we use photos that have brands, logos, or trademarks in the photo? For example, on a T-shirt, in the background on a wall, a billboard, TV, etc.
Boy, these are good questions. How concerned? I don't think that, I mean, trademarks are generally used to advertise, and whether or not we want to advertise on behalf of other companies is probably an administrative decision. I think that typically, I think generally best practices are going to be to avoid having marks on public display, but it's a very nuanced question, and it's a good question, but something probably to be evaluated on a case-by-case basis. Michelle, any thoughts on that?
I think what Ryan said is exactly right. And I think the thing to kind of keep in mind is, again, with trademark law, the issue always is likelihood of confusion. So the legal analysis will be, when you have that trademark in your photo, do people somehow think that there is an affiliation between your institution and that mark that's in the photograph? And so you really want to evaluate it in that way. But having said that, I think many companies are very aggressive in protecting their trademark, so it depends on what the mark is, and it's always safest to remove it, right? But, you know, you would want to get some advice on that, I would say.
Where is the mark, where is this photo maybe going to be displayed? Where is, how many other photos like it are going to be displayed? I don't know. It sounds like but it's a good question. It's the kind of thing I think institutions need to be thinking about. To be conscientious and so forth. So what makes a good trademark? Primary term is distinctiveness. This is something that's talked a lot about in the law and in the case law. How distinct is this from whatever else might be out there? So this is where a marketing perspective is going to be handy, right? And hopefully many of you have those kinds of people who are thinking about brands, and they're just better brands than other brands, right? And it's because the public identifies with it. They like the way it looks. They like the color, the presentation. What we're generally trying to avoid is secondary meanings. So a computer company that tries to trademark the computer company is probably going to have a hard time getting that trademark, because the words actually describe specifically what's going on. So maybe I've got that a little bit wrong, but I'm thinking it's really just secondary meanings. It's not about avoiding secondary meanings, but secondary meanings it's actually a good thing. Sorry, mistyped. Who wrote this thing? Gosh. So, for example, Apple computers could be a really good trademark because Apples have really nothing to do with computers. You see the distinction? Yes.
Brad from DATC.
Oh, no, that's not a question, that's me.
What?
That wasn't a question, sorry.
Would you like
I
to
was
answer the comment?
Oh, sure.
Okay.
Oh, my bad.
Brad said, well, you read it, then if it's you.
No, I was just gonna mention, like, a lot of photographers that have ever worked with IP are generally good at saying, oh, we need to cover up everything before we do a shoot, especially if it's something for, like, official a good thing to look to if you're hiring a photographer or a videographer.
Yes. Now, the process typically, trademarks are a little different than some of the other kinds of IP, and we've gone through patents, and we'll go through in detail copyrights in just a few more minutes. There are really kind of two registration procedures that can be used. There's a federal process and then a state process. Most states have their own copyright process. It's usually associated with the corporation department or the division of corporations, something like that. In Utah, that's the division that works on trademarks. And federally, it's done with the U.S. Patent and Trademark Office. These are just a few sort of comparisons, just super brief, but usually it takes at least a year to get a federal trademark. It can be done faster, and it can also take a lot longer, but this is just a general concept. In the state, it just takes a couple weeks, okay? And can be very rapid. Federal, this is a super broad estimate, but I think, I don't know if I've ever obtained a federal registration for under $500, and that would be pretty cheap. And it can definitely go up into the thousands.
Well, just the filing fee alone is $350 per class, right?
Yeah.
So.
Yes, and we'll talk about classes in just a moment and what that means. That the state is very nominal, and in some situations it can be free. Just to coordinate with the state, and they'll file it for you. But federal gives you national coverage, right? And state only gives you the state coverage. Now remember that I said at the very beginning, you don't have to register marks, okay? When we register marks, we get certain legal presumptions, okay? But the common law, and maybe this is why Congress didn't pass a trademark law until the 1880s or 70s or whatever it was, the common law does take care of trademark questions, and you can have trademarks exist just by virtue of using them. And we'll talk about some of the distinctions in just a moment. Here's a quick overview of the federal process, right? You create the mark, file an application, it gets examined, then it gets published so people can inspect it. This is where a company that is maybe very aggressive in its trademark portfolio is looking for things, and if they find something that looks similar to their mark that might be published, they will file what's called an opposition. Eventually, hopefully, it's registered, and then you have to continue to show evidence of use periodically. The state process is simpler. You create your mark, you file it with the division, it gets examined. It's a very brief examination process because it doesn't necessarily go into as much detail, and then it gets issued, and then you just renew it and you show evidence, continue to use it, and you're good to go. At a place like USU, we have a variety of federal marks. Most of our marks, though, are state marks. We find that our penetration outside of the state of Utah, as far as a brand, is not necessarily worth the extra time and expense of having a huge federal portfolio. And not to mention that even outside, we always have these common law rights, okay? So costs and examination depend upon these things called classifications or classes. And so I could obtain, hypothetically, a trademark for Apple chairs, and that would be a different class than Apple electronics or computers, right? And so you can, and you sometimes will see maybe something that has the same name but very different classes, and that's the way it works. So you don't get every class when you register. You get all of the classes you choose and you pay for. So the more classes that you want, the more expensive the application becomes. And you can imagine that, I'm guessing Apple, I don't know this, but I'm guessing that their they've chosen a lot of classes, my guess, right? And the more diverse the company becomes, the more classes they might want to enter into. For state institutions, I find that generally the kinds of classes that we're interested in are apparel, right, for our T-shirts and our ball caps, and maybe educational services or some kind of product or something like that could also be a category that could be used. But oftentimes our brands are associated with athletic type activities. Let's see. So, trademark symbols. Maybe some ideas on best practices here. You've probably seen all three of these symbols at some point in your life. I'm sure you have. The R means registered. The TM means that I'm using it as a trademark, and the SM is a service mark. Here are a couple examples of how USU might use these marks. Utah State University is a federally registered trademark, so we could put an R right there. Aggies is something that is hard to register federally because there are a lot of ag schools, and there are a lot of people whose mascot or nickname are the Aggies, right? And so we can't get a federal registration for that, nor would we want to, because it would make a lot of our peer institutions quite cranky with us if we tried. And so that's something that we just use as a trademark. So these symbols can be used. Oftentimes they should be used, but they don't have to be used. Sometimes you might see the symbol and it sort of looks like just this little blurb because artistically it just doesn't fit in with the design of the product that has that logo or trademark on it. So sometimes they'll take it off. So as you're walking around and looking at all of the ball caps that people might wear to the next game or whatever, don't be creepy, but check it out and see. You'll see a lot of different. Some of the marks will have an R. Some of them might have a TM, and some of them won't have anything. And really, what this does is it tells the public, I'm using this as a trademark. This is my space. Give me some space, right? And it's a notification, and it can give us additional rights. So, couple quick questions, and then we'll run through. These are questions that either came in, and I thought maybe we could run through them, and then we'll get into copyrights. I think we're right about good on time. So, what should I do if someone infringes my trademark? Well, you got to tell them to stop. If you don't tell them to stop, then you might lose it. Okay. If you know about it and decide to do nothing, essentially what you're creating a record of is, I don't care about this trademark, and I don't care, and maybe I'm not even using this as a source identifier anymore, right? So you got to tell them to stop. And if they don't, and I find that generally the best way to do that first step is to kindly ask them. For example, we had somebody use a Utah State University trademark the other day, a big company, a really big company. I'm not going to say who it was. And I called up their counsel, and I said, hey, did you know that you're using our mark? And he said, I had no idea. I'm so sorry. And they took it down off of YouTube immediately, okay? So I find that usually a quick conversation, oftentimes when people are using marks, they might not even know it. They might be doing it in ignorance. So I kind of like to give people the benefit of the doubt. And then if they fail to stop after that initial invitation, then you have to start bringing out the hammer just a little bit. You have to tell them, stop it, and we mean it. And if they continue to stop, then you're probably going to need to file a suit and get them to stop. If you don't, then you'll probably lose your mark. Okay. Or at least you'll lose the strength of that mark.
So do you normally escalate from like informal communication to a cease and desist? Do you normally escalate like from informal communication to a cease and desist letter to a suit? Is that'd be the general progression. Like you said, you just called up their
But I've never had to. I mean, honestly, I know that some places do a lot of cease and desists, and USU has to do those too, just from an efficiency perspective. You can't call up everybody, so sometimes it's easier to send a letter. But my experience is that typically when you tell people to stop, they stop. When you ask them to stop, they'll even stop. Because people don't want to expose themselves to the liability, and they recognize that we had somebody using the term USU a little while ago, and again, they hadn't thought it through, and we gave them a call, and they took it down immediately. So these things happen, and I think that just a professional courtesy call, actually it was kind of interesting with that large corporation when I called, we had no idea, oh, and by the way, thank you for just giving me a call, as opposed to, you know, ringing the siren and coming in, you know, guns a-blazing. So that's my experience. There are a lot of different experiences, though. Sometimes the right thing to do is to go hard from the get-go. So it's going to be specific to the situation. What should I do if someone wants to use my trademark? Well, first of all, make sure that it makes sense and that it's not going to confuse the market, okay? So if somebody wants to use your trademark to print it on a T-shirt, might be a good idea. And if you're going to do that, license it to them. Have some kind of written agreement. That written agreement will help protect your mark. It needs to include some things, and your counsel will be able to advise you on what that needs to include. It needs to include things like quality monitoring, being able to inspect things, and it should include some ownership acknowledgments and other such things. Let's see, what should I do if someone notifies me that I am infringing their trademark, right? This happens. It's pretty easy. Stop doing it. And talk with your counsel and stop it. It's a pretty easy one, and they may continue to call you. They might demand some kind of a payment. You know, I've talked with Risk before on these questions. Sometimes they'll call and say, hey, what have you had any experience with this? We've never really had to. It's a rare thing to need to pay out something for this kind of a thing. Just stop doing it, and you'll probably be just fine. Michelle, you may have more experience or hindsight in that, but
in our experience on trademark, I don't think we've seen too much, or I don't think we've ever had to pay. I think copyright infringement's might be a little different sometimes.
Yeah, that's the same for us. Let's see. What are the kinds of consequences for a legitimate suit? Well, you could have to pay damages if it's registered. You might have to pay statutory damages, and you'll certainly have to stop using it. And kind of finally, I think just a few talking points to consider as public institutions. We do have a great defense of sovereign immunity. It's actually been shown in the courts in many situations to be an effective defense if it really escalates to a lawsuit. But I think that even with that sovereign immunity, and even with the potential of being able to defend yourself with that defense, it's not good to be cavalier with other people's trademarks. In fact, it's a really bad idea. It shows a bad citizenship component to it. It can have big PR considerations. We had a university try to run on something that meant to they tried to trademark a concept, a slogan that is very popular at USU a little while ago, and the PR that they got as a result of that attempt was probably the biggest damage. So running roughshod or trying to trademark or trying to step on other people's toes or be a bully, it just doesn't seem to work out very well for the person or a company. And we're really trying to reduce liabilities and exposures for our institutions. And so even though we've got some great defenses, the best practice is be conscientious, and be considerate of other people's trademarks.
Right, and even if you assert sovereign immunity, you can have to pay attorney fees, which can be very expensive. It can still be very expensive, so we never like to, we just want to comply with the law.
Yeah, compliance it's really the only way to go. And we've had questions throughout. I'm going to get out of here. Go sit down in another place. I'm running for the exit. I'll turn the time over to Michelle and give us a second here while we transfer microphones and other such things.
We have one quick question. What is sovereign immunity?
Here, I'll answer it. Can I speak loud enough? Sovereign immunity is the defense that a state institution can make. It essentially has roots in, the king doesn't permit itself to be sued. You can't sue the king. That's the origin of it, and it exists in our government system today, and it's something that we say, we're the government, so we're not going to let you sue us.
Would that go for school districts as well, or is that primarily for like the state institutions, state agencies, higher ed?
It would cover state, anything that's a part of the state.
Okay.
All right. Okay. So I feel like we need to have a break, and people, it's like 3 o'clock, 2 o'clock. It feels like 3 o'clock. Maybe everybody needs to
Thanks, Michelle.
stand up.
That
was so awesome. It was, really. It was great. Thank you so much. But I realized how people need some caffeine and sugar, maybe. Okay. So copyright overview. So Ryan has talked to you about trademarks and patents. And I want to give you an idea of how copyright is different from that. Because people often, I don't know if you get this, Ryan, but people will call our office often and they will think, they'll call something copyright that's really trademark. They don't really understand what the difference is. So for copyright protection, what copyright protects is, I'm going to go to this, examples of copyrighted works. So typically it would be anything that is fixed. So a story, a poem, a photograph, a sculpture, a design, anything that's fixed and is a creative, it has to be sufficiently creative and fixed. That is subject to copyright. And so when you're considering whether something is subject to copyright, either if you're thinking you've created it and you want to own it, or you're thinking about, are you using someone else's? To know whether it's subject to copyright, it has to be sufficiently original. Because going back to what Ryan said, the Constitution wants to encourage creativity. So some things that would not be subject to copyright would be the telephone book. There's nothing really creative about that. That's just a list of names. So if it's not creative, it's not going to be protected. So it has to be creative, and it has to be fixed. So fixed means, you can look at it, like this. If, say, for example, a choreography that hasn't been notated, if I just dance here, that's not subject to copyright. It might be creative, but it's not fixed. It's not subject to copyright. Okay? So it's important to understand, once you have something that is subject to copyright, what are the rights that attach to that? Well, copyright is often thought of as a bundle of sticks. So these are the rights that are covered by copyright. The first one is the right to copy. That's the most obvious one that people usually think of. So if, I had written this handy little, if this were a poem or something, and you copied it, that would be infringing my copyright. So that's the first thing. The other rights are to distribute copies, to publicly perform, to publicly display, and to make derivative rights. These are all individual rights that are separable, and we'll talk about each one. So the fact that they're separate, it's a bundle of sticks, and you could pull out each one. You could have the right to copy. You could have the right to publicly perform. That's called divisibility. Each one is separate, and if you have the copyright, it doesn't mean you have you could license out these different rights, okay? So when you're the reason this is important is if you are getting permission to use a copyrighted work, you want to make sure you have the proper type of authority. You have the right, are you needing the right to copy it? Are you needing the right to publicly display? Are you needing the right to publicly perform? You have to make sure you have that appropriate type of permission, okay? Okay, so we're going to talk about each one of these. So the right to copy. So here's an example of a case, and on the left side, you will see a photograph of these two individuals with these puppies. So a photographer took this picture, made several cards of it, and was commercializing this. There was a famous contemporary artist named Kuhn, and Kuhn used that photograph and made this kind of sculpture with wood out of it. And he made about almost $370,000 on his marketing of his this artwork. So he was sued for copyright infringement. And the test for copyright infringement is it substantially similar, and is that similarity material? So the court found in this case this was an infringement. He tried to say, well, it isn't really, because what I've done with these puppies, I've exaggerated their noses, I put some daisies by this woman's ears, I've made it a little bit different, but it really is substantially similar, and the court found it was infringement, and he was held liable. So that would have infringed the right to copy.
Now, if the gentleman who originally took the photo, if he had commercialized it as a photo he took, you know, for a personal album, then, and he happened to see a picture of that, I mean, is that something where he would have as substantial a case in a court of law?
So say that again, if you've done what?
The original picture, it was just a picture, you know, I have it in my photo album. And
Right.
on the internet, I see someone has a photo that happens to look just like it. I mean, I guess why would you ever take that to a court of law? But, I mean, because you have that substantive, you know, commercial component to it, then you've actually got a case.
Yes, you do, because for one thing, in order to have, there are a couple of things if you infringe someone's copyright. If you have a federal copyright registration, and we'll talk briefly about that, you can get what are called statutory damages, and that means you'll have a minimum amount of damages that the court will award you, and the court can award you your attorney fees. So you'd get a minimum of $750 per infringement, up to $30,000. If you had a federal copyright registration. Chances are the photographs that you have in your photo album, you have not gotten federal copyright registrations on, because why would you? So if you don't have the registration, you have to just prove your actual damages. You'd have to prove, like, how was I harmed by someone taking my family photograph?
Yeah, I guess
See, in this case, he was commercializing.
Like, it was like a smaller scale thing. Like the photo hadn't done well.
Yeah.
It's kind of a dumb question, actually.
No, it really goes to damages, which is really a pretty interesting question if you're a lawyer. Anyway. Okay, so the second right, the right to distribute copies. So think of this as sort of like films, when you're like distributing films. That's a specific right under copyright, is your right to control that distribution. I'm not going to talk about that. The next one is to publicly perform. This is a really important right that people sometimes don't think about. And this will come up, I think, for schools. It certainly comes up at the university. And that is, say you have someone who, you have a dance group, and they're going to perform a choreographed piece. That involves the copyright, the public performance of that copyrightable work. Say they're performing some music. That is the public performance right. Like, for example, you might think of a band, you might have a band at your school who's doing a cover of some famous group's music. Well, that will involve the public performance right. And so you have to evaluate whether you need permission for that. And I'm going to talk a little bit more about blanket licenses, but generally, yes, you would need you'd need copyright permission to do that performance. The next one is publicly display. So, you know, if you had a piece of artwork, you need to have the right to publicly display. Now, one thing that's really important to keep in mind is many people think that if I bought a painting, right, people might think, I get the painting and I get all the rights associated with that painting. I don't. I purchase the painting, that's all I have. The artist still retains the copyright to that painting. So they still have the rights relating to anyone who wants to make copies of it. Just because I bought the painting doesn't mean that I can go out and make a bunch of cards and sell them. I can't. The copyright owner is the one who has those rights. All of the items that we've talked about still reside with the author of the work, okay? And then the last one is to make derivative works. And sort of the classic example of this would be making a movie from a book. So you're taking an original work, you're transforming it slightly, you're making a derivative work. Okay, so those are all of the rights of copyright, but there's a really big exception to copyright, and that is fair use, which you've probably heard of. So it would be an infringement of copyright to do any of those things in the bundle of copyright unless what you're doing is fair use. And fair use is a very kind of murky concept, which I know isn't really comforting to anyone, but it really can provide a very good legal defense if you go through the steps of doing a fair use analysis. So we're going to go through those, and if you have fair use, you could go ahead and use something even if you don't own it and even if you don't have a license. Okay. The first fair use factor is the purpose and character of the use. So let's take an example and kind of run this through. So say we had an excerpt from a book that we wanted to use, and maybe it is a piece of criticism. So say we're using it at an educational institution. So is that a nonprofit educational use? Yes, that would weigh in our favor. In addition, it's for criticism commentary, that would weigh in our favor. One really, really important factor under number one is whether your use is transformative, and that means, are you using it for a different purpose than it was originally created for, and are you adding something new? Again, this goes back to the driving force of copyright, which is we want to encourage creativity. So if you really are using it in a different way and you're adding something to it, that will weigh heavily in favor of fair use. The second factor is, oh, well, this is the other part. If it's commercial and it's non-transformative, that will weigh against fair use. So the second factor is the nature of the work. If something is factual, that will weigh in favor of fair use because factual things aren't so creative. And the law doesn't want to restrict people's ability to use factual things. So the more factual, the less protected it will be. The more creative, the more protected it will be. So in this particular case, if this were an excerpt of a factual book, that would weigh in favor of fair use. If it were a poem, that would weigh against fair use, okay? The third one is the amount and substantiality of the portion used. So in this case, we're using an excerpt. That's just a small portion that will weigh in favor of fair use. If you were using an entire thing, that would weigh against it. Or the larger the percentage, the less likely that you could get fair use. Unless a really critical caveat here is the heart of the work. If you use a small amount of something, but it's really the heart of the essence of what it's all about, that's going to weigh against fair use. So you have to kind of figure that out as well. And then the last thing is the effect on the market. What if your type of use were widespread? What effect would that have? And one thing that you really have to consider here is there an active market for permissions of the type of thing that you're going to do? Could you get online and would there be, I want to do this X thing with this photograph. Yes, you can do that. You have to pay $50. If there's an active market, that will weigh against you. So in our particular case, if we had an excerpt of a book, it was educational criticism. We used a small amount. It was factual. And chances are for a small excerpt, there isn't going to be a market. You're going to have a strong fair use argument in that case. Okay? So you're going to be fine. You don't need permission. You could go ahead and use it. So I'm going to go through a couple of examples here. These are some other considerations on effect of the market if your use competes with the sales of the original that weighs against. Okay, so here's a case that dealt with the Baltimore Ravens. So there was an artist who put together this shield and submitted it to the Ravens. When they moved to Baltimore, they were looking for a new logo for their team. They got that logo. They didn't choose it, but they got their own marketing team, and ultimately they came up with that. So they used this for 2 years. The Bouchard, who created this, sued them for copyright infringement, and he won. This was found to be substantially similar. Interestingly, this kind of goes to your question, he didn't actually have any damages, though. He couldn't really prove damages. He hadn't really been using it in any way. So he kept trying to get them to just stop use. Well, they stopped use after 2 years, but then they had, in their team headquarters, they had a bunch of historical memorabilia of the history of the team. Well, included was this insignia on the team's helmet, different, photographs or things there. They also had some films with footage of the team at different times, and he wanted them to remove all of that. He wanted this insignia off everything. So this got the attention of a lot of the film industry, actually, when he wanted them to not be able to do historical films. And there were a number of briefs filed on behalf of the Baltimore Ravens because filmmakers said, we really don't want to be limited in our ability to put together histories and to really educate the public in that way. And the court agreed. And the court said this was fair use. They also said there was sort of a First Amendment issue, and it was fair use in terms of the way they were using it. So there's one example. Yes?
Maybe just one thing to point out here is sometimes this is where copyright and trademark intersect.
Good point. Yes.
And you'll note that there's a TM. So because this trademark is fixed, it is also copyrighted. And so both laws apply, but they apply in different spaces. Mm-hmm. So the owner of the copyright and trademark has different rights depending on which way they would assert it.
Right. Are they using it as a copyright in the copyrighted way or as a trademark? Yeah, and so that's a really good thing to keep in mind because virtually every logo will have copyright associated with it. Not just the name, like when you had just Utah State University, that won't be a copyrighted issue. You can't copyright short words and phrases. They're not creative. But the logo is subject to copyright and trademark.
So for this, was he awarded anything? I mean,
Well, he lost.
Oh, he lost it.
He lost because
And
he was still claiming that, and they said, no, this is all fair use. Our historical use is a fair use.
Oh, so he
and
won
the court
initially
agreed.
and then lost.
Right,
in a different
right, exactly. Won but no damages, and then he lost on injunctive relief, which was you have to stop using it in any way at all. And the court said they don't have to stop using it in every way. These historical uses are permitted fair uses.
But he wouldn't have had a case if he would have sought damages. It's like potential loss.
Right, and again, he obviously didn't have a copyright registration, or he could have gotten statutory damages. So there are always these benefits to getting registrations, but you sort of have to weigh how likely it is that you would really want to enforce those because, you have to go through steps to do that. So, okay, here's another case that I thought was kind of interesting. So this is the Korean War Memorial in Washington, D.C. So this was commissioned by an artist to do this war memorial. And as we've talked about, the person who owns the copyright is the person who actually created the work, unless it's an employee and it's done within the course and scope of their employment. So all of us, as employees, if we're creating something, our employer's paying us to do it, our employer owns the copyright. But if we're doing it, we're an artist, we will own the copyright. So this is a really important thing to keep in mind. If you're ever commissioning an outside entity to create something for you, you want to make sure you get an assignment of the copyright because, again, they might give you the sculpture, they might give you the photograph, but the copyright does not transfer unless you have an assignment in writing. So in this case, they commissioned this artist to do this Korean War Memorial. And a few years later, a photographer went to the memorial. His father had been a Korean War vet, and he took some pictures and it was this snowy time, and it was just this really cool effect of sort of really getting the sense of these soldiers out there with the snow and everything. And so then it was the anniversary of the Korean War, and the U.S. Postal Service wanted to do a stamp. So they did, and interestingly, this is, I think, a very interesting example of how you can have layers of copyright, because you have an original copyright in the sculptures, also have a copyright in the photograph. And so really, the photographer should get permission from the sculptor. The post office got permission from the photographer, but didn't get permission from the sculptor. So they did this, issue of these stamps, made a whole lot of money on them, and the sculptor sued. And the court found that it was infringement. And they tried to say this was fair use, and they tried to say it was transformative. This really is different, right? This has the snow, it looks different, we've added something, and the court said the fact that nature snows isn't really, that's not really transformative, right? And so ultimately, there was infringement found. So this is a handy reference tool that I would encourage you to use. It's an online fair use evaluator. It will take you through those 4 steps that we just discussed. So whenever you're using someone else's work and you think you have a good fair use argument, I would encourage you to go through this evaluator, and it can help you print something out at the end that will memorialize your analysis of whether you think you have fair use, and that will be a helpful defense if you should ever have a complaint about it, which we hope you never will. But it's helpful to go through that fair use analysis, and it is also helpful in terms of some defenses that we might be able to assert. Okay, this was another case I liked. I just thought this was kind of funny, kind of going to the ownership of copyright. So there was a British photographer who went to Indonesia a few years ago, and he brought all of his expensive cameras and was hoping to get just the right picture, and he was taking photographs of these macaques. And so when he was trying to do these photographs, this particular, I'm just going to call him a monkey, picked up the camera and took this selfie. And it was an amazing picture. It was just like, that is awesome. That is the best picture. I love it. So he came back. Under British law, he was actually able to get a copyright registration. But in the U.S., could he get a registration for this? Because who owns the copyright? Who owns it? The person who took it, right? So he didn't actually take the picture, right? So Wikimedia put up this picture, and he said, you need to take this picture down. That's my picture. And they said, you didn't take it. The monkey took it, right? So he was very frustrated. Then, interestingly, I love this, PETA got involved, the People for the Ethical Treatment of Animals, and they said, so this monkey's name was Naruto, and they said Naruto should own the copyright to this. Monkeys should be able to own the copyright. They're entitled to more protections. Right around this time, the Copyright Office issued a circular saying, animals can't really own a copyright. And ultimately, the court agreed and said there's nothing in the U.S. law that suggests that animals can own a copyright. So I just thought that was a fun case. And it kind of just helps you remember who owns the copyright, right? It's the person who actually creates the work, unless it's a work made for hire. Okay, I'm not going to go to that. Okay, so these are just a few kind of commonly answered or asked questions. So sometimes we'll get questions of, there's an image on the internet. This seems like, the perfect image. I'd like to use it. Can I just right-click, copy it, and use it on my website? What are your thoughts on that?
It depends on your audience, one.
Okay.
And it depends on what kind of copyright that image has. It could be a public domain photo. A lot of times, I do a lot of this as an instructional designer.
Good.
We put images in courses all the time. And so sometimes you'll have to contact them, or, did you buy it through iStock Photo? Something like that, where it's a marketplace, so that's easy peasy. But for the most part, if it's an internal audience, I don't worry as much. If it's an external audience, I worry a lot.
Okay, I think that's a really good answer. And it highlights, so number one, the fact that it's on the internet, does that make it okay? The fact that it's easy to get? No, it doesn't, right? And some people think that, oh, well, it's just on the internet, that must be fine. That's not the case. So what you need to do is assume you need permission, right? That's what we always start with. Assume it's protected. But you would look at the terms of use of the particular website, and there might be a Creative Commons license that permits the use, or it might be free. You would need to look at that, right? And make sure that whatever's permitted, that the scope of what you're doing is covered, or it's fair use. So you would go through that same fair use analysis, and if it's fair use, then you're fine. Go ahead.
All right, so we have two comments. Brooke says it depends on what kind of rights are associated with the photos. For example, in Google, you can go and search for free use for administration or commercial, so you can look it up that way. And then Suzanne asks, how much of a book can I copy to distribute for educational use?
Okay. So that's a good question. And so a couple of good points. That's exactly right. Going back again to sort of the nature of the use and what the terms of the license are. And then how much of a book can you copy for educational use? So it really goes back to your fair use analysis. And are you using it for an educational nonprofit use? Is it factual? Is it creative? How much of the book are you using? There are some guidelines that were agreed upon for copying for classroom use that would generally say if it's 10% or less of a book, then you would be okay. Those are not law. That's just sort of an agreement, an industry agreement. And then you'd need to know, is there a market for permissions? Is there an established market for the particular amount you're using? So it really is just a fair use question. Okay? Okay. We talked about that. Okay. How about posting music on a website? Is that okay? Okay, again.
Hold on one second.
Yeah, go ahead.
Before we move on. Is it okay then to use photos on Creative Commons that are labeled for non-commercial use?
If your use is non-commercial, I mean, you'll have to figure out what it is you're using. If you're just using it for an educational purpose in your institution, I would say yes.
Okay.
So, yeah. Okay, so can I post music? So at the university, we have blanket licenses. The ASCAP, CSAC, and BMI licenses, they specifically permit us to use music that is in those databases on our website, as long as it's a Utah EDU URL. So what you all would need to confirm is, do you have blanket licenses? And if not, is it somehow free? Otherwise, you need to be really careful. I would say generally, you need to be really careful about anything you put on the internet, because the risk of enforcement is just much, much higher if it's on the internet. So, yes?
Sorry, we have an expansion on the last one for Creative Commons. She's referencing such as a job advertisement for an agency. So is the job commercial or not?
So did they get a job description and they want to put that?
I guess, like,
I'm not sure.
I'm not sure what she means exactly, but I imagine it's you're putting a photo, a stock photo.
Oh.
Like take a photo of someone doing something that would illustrate the job or having fun, like they're having a job.
Yeah.
That's what I imagine she means, but I'm not sure.
No, that seems a little bit in between. What are your thoughts, Ryan, on that? Whether that's a commercial use?
I don't know. It seems like one of those where my general approach is, if there's a question, there's just so many photos out there. Go find one that's free or in the public domain. Is it really?
Yeah.
Is it worth it? Right?
Yeah, absolutely. Okay.
Whether or not it's worth the time to evaluate is sometimes
Right.
right?
Right. Just get a free one for sure, right?
A myriad of options out there,
Yeah.
and the Creative Commons database that is so broad now, where there's so much material, it might just be easier to just say, you know what, I'm going to find something else. But I don't know. It's a case-specific thing.
Okay. Go take a picture of your coworker just to love it in their cubicle.
Right.
Okay, our next question is educational use confined to academia, or does it apply to employee training too?
I think you could use it in a broader context of educational. I don't know that there's something that says it has to be only in academia.
Okay. And then last one, what about copying short stories or poems found on the internet for student use?
Again, for student use in your classroom, I would say, I would check to see if there is a market for permissions for that particular poem or, you know, story or whatever. And if there really is, you have to be very careful about that. If there isn't any market, then I think, again, it's an educational use. Creative goes against you. You're using all of it, but you're not really harming the market. And the first and the fourth factors tend to be the strongest factors overall. So if there's no market, I think you'd be okay. Okay? Next one. Okay, can I show a movie on campus if I don't charge admission? So the answer, you guys are so great, my audience here says no. And that's exactly right. This would violate the public performance right. So the question here is it just a small group? Like at home, if you're just having like a small group, of course you don't, it's not a public performance. But if it's open generally to the public, it is a public performance and you do need to have permission to show that film. All right, this tells you a little bit more about what a public performance is. How about you've put together this great video of your school team, and you found some terrific music that you think is great, but you didn't create it. And it's just on YouTube. Is that okay?
YouTube will strip it anyway.
What?
YouTube will strip it if you didn't link to it or...
Right. There's nothing different about it. I mean, putting it on YouTube's just the same, right? And you have to make sure that you have the rights to do that. All right. So, any other questions? I mean, these are really sort of the same thing. Images for educational use. The fact that it's for education, some people think if I'm using it for education, is that fine? It just means there's a general exception for education. There is not a general exception for education. That definitely helps you in your fair use argument, but it's not the end of the analysis. You have to go through all 4 fair use factors.
Quick question on that. Like I know,
Yeah.
I remember working in a bike shop even and saying, you know, when I'm listening to this CD, and someone said, oh, technically, there's like an audience limit. Is there a static audience number for movies or music or anything like that where, you know, it's fine for your own personal use and then it becomes like general audience use where it's frowned upon? Is there a reference for that kind of thing?
Well, it's just like the standard is back here on that. Whoops. Oh, sorry. Public performance is a place open to the public or at any place where a substantial number of persons outside of a normal circle of family and its social acquaintances is gathered. That's the standard.
Okay, that's right there. Gotcha.
Mm-hmm. Okay.
But when you go to a retail store and there's music playing over that loudspeaker,
They pay for it.
there's a license.
Mm-hmm.
They should be paying for it.
Right? I'm sure they are.
Yes, of course.
Of course they are. Exactly.
We have a comment. On YouTube music use, I've posted videos with commercial music, and YouTube has alerted me that someone else owns music, and I cannot monetize that video. Just a comment, I think.
Yeah, exactly. That's exactly right. That's what will happen. Mm-hmm. Okay, so if you are creating anything that you think, you know, might have some commercial advantage or you think that might be likely somebody will infringe on, it's good to get the copyright registration. It's really easy to do, and I've just included the URL to the Copyright Office. It only costs about $50. It's pretty simple, and you really do get significant rights if you do the federal copyright registration. So that's just a resource for you to have available.
All right, Sean wanted to add that they did let the video be posted. He just couldn't monetize it on YouTube. But then Jenny has a question. Do you need permission to use a song not created by the school for the school dance? We pick a song every year, and the student body learns to dance to it. Sometimes it gets posted on Facebook also. Do you need permission for that song?
For the song to be the theme of the dance?
And then they learn a specific dance for that theme, yeah. It's like they do dirty dancing, and they make up their own dance to it, for example.
But then they post it on Facebook.
And then it's on Facebook.
Oh, well,
But
see, that's the...
But why would they do dirty dancing?
I'm sure it's not that one. That's definitely not, no.
It's just a grade.
technically, right, I mean, you could have a public performance of that and you could be infringing. Again, if you have any sort of a blanket license, like at the university, that would cover it, right? So we wouldn't have any issue there, so you'd have to see if there is a blanket license. I also think there is a practical enforcement issue. If you're really playing a song in one small room, you're not putting it on the internet. I mean, chances of someone complaining are probably fairly low. You put it on the internet, though, it will dramatically increase your practical risk that someone will complain.
And I think this is one of the risks that has occurred in today's age where you don't know what might go viral, right?
Yes, good point. Yes.
And so maybe it depends on how good are the kids at dancing, maybe, or bad, because I guess it goes either way.
Yeah.
But we just don't, we can't keep people from filming things nowadays, and there's just so many recordings that are going on at all times. It's probably best to play it safe.
I would say so too. Yes.
Another one, is there a higher degree of culpability for higher ed than public schools?
No.
All equal.
Okay. Images on social media, this comes up a lot. People might be putting things on Facebook. Again, I just highlight this to say there is no different analysis. Sometimes people think it's fine, I'm just putting it on Facebook, or I'm just putting it, the analysis is just the same. If you're using someone else's, kind of going back to your question, I mean, if it's your friend's photograph, how much will they care? But if it's a commercial photograph, I mean, I would, be very careful. And I just think anything you're doing officially as part of your duties as a public employee, you want to be very careful and make sure you have appropriate permission.
Legal argument of what is your online private or family space? Is your Facebook considered a personal space? Depending on your permission, or does it depend on your, I don't know, it's all another bag of worms, I'm sure.
Yeah, that is an interesting question. If you only have 3 friends on Facebook, maybe it's not a public display. If you're really not popular. Okay. Any other questions? All right. Well, thank you, everyone.
Have a round of applause for our presenters.
Thank you all for your time and attendance in this and all the great questions that we received. We really appreciate your attendance here. This presentation will be archived, and you'll be able to watch this online. We'll post a link on our website in case you missed any of it. We'll also ask the presenters. Actually, no, I'm just going to say we're going to use the presenters' presentations and pretend that it's educational purpose, and it will be transformational because you will be transformed when you read through their slides. No, we will make sure we get their express written permission to use these slides. Are there any questions before we close? Yes.
We have one online. What if the dance song has a blanket license? The university does not record or post video, but a student does, and the university was using it. Who's liable?
Well, I think, again, you have to look back at your blanket license and what it covers. Say, for example, the ASCAP CSAC BMI licenses at the university would cover the performance at the university, but it may not cover putting it online. So you really have to figure out what it is that you're doing. But if a student, so say you had the performance and it was appropriately licensed at the school, and the school didn't post it, but some other individual took a video and posted it, I would say that person is the one who's responsible. They're the ones who made the copy and put it out. Unless the school knew, was sort of on notice and somehow provided any means for doing that, they could have contributory infringement responsibility.
Excellent. Oh, go
I
ahead.
have a question, actually. So we played it safe already, and we took care of it, but just hypothetically, we're currently developing a training, and we wanted to use the YouTube video.
Hypothetically, here's a real scenario.
Okay. We used a YouTube video clip, or wanted to use a YouTube video clip from a government agency in London, Transport of London. It was on I think at least 15 different channels on YouTube. I mean, it's everywhere, and it's years old. We decided to go get written permission anyway, but since it was on YouTube, since it was old, since it was public, it was educational, could we have used that in theory, or should we have gone and gotten it like we did?
Again, you just have to go through that fair use analysis. And were you using it, like, for your particular use of that YouTube video, was it a transformational use? Were you doing it for a different purpose? Were you adding something, or was it really just the same? Was that sort of for entertainment, you're also using it sort of?
It was to illustrate our point, our purpose, and then we added on and added our own quiz on top of it.
It was transformational, I swear.
And it's for education. I mean, you might, is it nonprofit?
Yeah, completely.
So, I mean, you might have number one. How creative was the video? Was it creative or
It
factual?
was an awareness test.
Oh, an awareness test.
So yeah, how many times does a white team pass the ball?
Oh,
And
so
then
that
if you
means-
notice a moonwalking bear while they go through.
Okay, that seems more factual than creative to me. How much of it did you use?
All of it, because we want to give them credit.
And is there any market for permission?
Not that we could find, but we got it anyway. So.
Well, if there was no market for permission, you probably would have had a decent fair use argument, I would have thought.
Heck, yeah.
Good to know. Well, great. Hey, thanks again, everybody. We appreciate your attendance. Thank you for all of those of you attending online for your patience in us while we got the link up and running. We look forward to doing these in the future. We will send out a survey to see what you thought of the presentation, and we'll get this information posted on our website and let everyone know when that is available. Thanks again, and have a great day.